I'd like to take my time this morning to suggest that combining our oversight hearing of the Department of Justice with the nominations hearing for Acting Attorney General Blanche would be a grave mistake for the committee. I don't believe we did that with Attorney General Garland, and I think the record of the Department of Justice under Todd Blanche lends itself to very vigorous oversight. Oversight which we have been denied because when we ask questions, we get scripted litanies of insult and quarrel rather than actual answers to our questions. When we ask for documents and records in writing, we get nothing. We are reduced to filing FOIA requests that are then not even complied with as FOIA requests. So the oversight function of this committee is really, I think, being systematically disabled. That's particularly significant when you have Attorney General Bondi saying that it was Todd Blanche who was responsible for the Epstein files disaster, the releases of private information and images of victims, the cover-up of documents that named Donald Trump, and just the general incompetence of the whole wretched mess. I don't think that it would be a good idea for this committee to be complicit in covering up the cover-up of the Epstein files. Move on to the Slush Fund, which a great number of my Republican colleagues have expressed real reservations about, with its attachment of a tax amnesty deal for Trump, the Trump family, and the Trump businesses. There are very legitimate questions to be asked about that, including, has that cockamamie idea really been withdrawn, or is it just being hidden briefly so it can resurface in some other fashion? We should be looking into this as a committee. It's important stuff. And even if we shirk our duties at looking into all of this, it appears that a Florida court is going to be looking into all of this. And I think it's a bad look for the committee to be turning a blind eye to what went into the slush fund deal and the tax amnesty deal, and then discover through a court proceeding in Florida all the stuff that we failed to look at. It's hard to be taken seriously if we have failed to do our own duty, and then the court proceedings reveal the mischief. I will say that I've looked. I have never, ever heard of senior officials of the Department of Justice being called before a court with respect to a fraud upon the court. Look up fraud upon a court. It's a pretty serious charge. This one was raised, I guess I should say, by 3 dozen retired federal judges, some very, very respected ones, some very, very conservative ones. And the judge in the proceeding in Florida, out of which the slush fund settlement emerged, reopened the case to have a look. She asked for responses. She suggested that the DOJ might have violated its own policies in this settlement. She suggested that there was an IRS defense memo out there that would be relevant to the proceedings. The violation of DOJ policies would obviously be a matter for DOJ to answer. The IRS client memo would obviously be something for DOJ to answer. She also questioned whether there was collusion. It takes two to collude. It would be a collusion between the Department of Justice lawyers and Trump's private lawyers. So there's another reason for the Department of Justice to have responded. What happened last Friday? No response from the Department of Justice. First ever accusation of senior level Department of Justice people of fraud upon the court with an invitation to rebut the allegations, an invitation specific to Department of Justice conduct, and they duck. So that is going to continue. The 36 judges have their answer this Friday, and then the court will go forward. I will contend that we don't look like much if that information is being developed in a federal courtroom and we haven't been allowed to ask questions, and indeed our oversight has been collapsed into a confirmation hearing. I have never seen a Department of Justice as badly run as this one. I've never seen fraud upon the court allegations. I've never seen so many suggestions of contempt. I've never seen so many no true bills. I've never seen so many cases thrown out. I've never seen so many accusations that department arguments were false, were pretextual, were designed to fool rather than inform the court. And we see that over and over again from judges appointed by every president. It is now at the point where the Department of Justice and the US government have lost their presumption of regularity in federal court proceedings. All of this matters. All of this is something to which this committee should be paying attention. And with respect to what our chairman has said about the norms of the committee, well, one norm is that US attorneys come through this committee after a process of consultation before they get to run US Attorney's office. Over and over again, we see these slippery deals where acting US attorneys are appointed, and then the first assistant is fired, and when the time runs out on the acting US attorney, they slip back into the first attorney position and leave a vacancy. It's an obvious scam to get around this committee's norms. And we have put up with this. It didn't happen once, it didn't happen twice, it has happened over and over and over and over again. And on top of that, we've seen US attorneys called out for misconduct over and over and over again. None of this is normal. None of this is normal. And the fact that this committee won't look into it, I think, is a shame. And I think if we try to be complicit in failing in our duty to look into this by combining the Blanche nomination hearing with the Department of Justice oversight hearing, we will have made a very, very grave mistake. Thank you, Chairman.
What you just heard is not a question. It is not a cross-examination. It is not a senator pressing a witness on a specific document or a specific date. It is something rarer and in some ways more consequential than any of those things. It is a senator placing an institutional indictment into the permanent record of the Senate Judiciary Committee, a formal, sequential, documented case not against a single nominee or a single decision, but against the operating condition of the Department of Justice itself. And it was delivered by Senator Sheldon Whitehouse of Rhode Island, former United States Attorney, former Attorney General of Rhode Island, a man who has spent decades inside the institution he is now describing from the outside. He opened not with an accusation, but with a procedural objection. He said combining the oversight hearing of the Department of Justice with the confirmation hearing for Todd Blanche would be a grave mistake for the committee. He said he did not believe that was done with Attorney General Garland. He said the record of the department under Blanche lends itself to vigorous oversight that, in his view, the committee was being systematically denied. That word systematically is doing significant work in this statement. He is not describing a single failure to answer a question. He is describing a pattern. When the committee asks questions in hearings, he said it receives scripted litanies of insult and quarrel rather than actual answers. When it asks for documents and records in writing, it receives nothing. When it files FOIA requests, the most basic statutory mechanism for public access to government information, those requests are not complied with. He said the oversight function of the Senate Judiciary Committee is being systematically disabled. That is a specific institutional claim. It is not a characterization of a policy disagreement. It is a description of a process by which a congressional committee's constitutional oversight function is being made inoperable, and Whitehouse placed it into the record as the foundation for everything that followed. He then moved to Epstein. He cited Pam Bondi, Trump's own former attorney general, as the source of the description that Blanche was responsible for the Epstein files disaster. He used Bondi's own attribution deliberately, not a Democratic critic, not an opposition researcher, the person who previously held the office Blanche now seeks, named by name, as the source placing responsibility for the file release on Blanche directly. He described what that disaster included: the release of private information and images of victims, the cover-up of documents that named Donald Trump, and what he called the general incompetence of the whole wretched mess. He then said something that is now in the permanent record of this committee. He said he did not think it would be a good idea for the committee to be complicit in covering up the cover-up of the Epstein files. That sentence is worth examining precisely. He is not saying the committee is covering up the files. He is saying that combining oversight with a confirmation hearing, thereby limiting the scope and depth of inquiry, would make the committee complicit in protecting from scrutiny the conduct he has just described. The mechanism he is objecting to is procedural. The consequence he is warning against is institutional. He then moved to the slush fund. He noted that a significant number of Republican colleagues had expressed real reservations about it, particularly the attachment of what he called a tax amnesty deal for Trump, the Trump family, and the Trump businesses. He asked a specific question that is now in the record. Has that idea really been withdrawn, or is it being hidden briefly so it can resurface in some other form? He then raised the Florida court proceeding. He said it appears a Florida court is going to be looking at all of this, and he made a specific institutional argument about sequencing. It is a bad look for the committee to be turning a blind eye to what went into the fund and the tax amnesty deal, and then discover through a court proceeding all the things the committee failed to examine. He said it is hard to be taken seriously if the committee has failed to do its own duty, and then court proceedings reveal the mischief. Then Whitehouse addressed the fraud upon the court allegation. He said he had never in his career heard of senior officials of the Department of Justice being brought before a court on a fraud upon the court charge. He noted that the allegation was raised by 36 retired federal judges, 36, some highly respected, some highly conservative. He noted that the judge in the Florida proceeding reopened the case to examine it. He described what the judge asked for. She invited responses. She suggested the DOJ may have violated its own policies in the settlement. She pointed to an IRS defense memo she believed was relevant. She raised the question of collusion, which Whitehouse noted takes two parties to commit. In this case, Department of Justice lawyers on one side and Trump's private lawyers on the other. Each of those points was a specific invitation for the Department of Justice to respond. Last Friday, Whitehouse said no response came. The first ever accusation of senior-level Department of Justice officials of fraud upon a court. A direct invitation from a federal judge to rebut specific allegations, an invitation targeted specifically at Department of Justice conduct, and the department went silent. He said, they duck. He then stated something that carries the weight of everything that preceded it. He said he has never seen a Department of Justice as badly run as this one. He has never seen fraud upon the court allegations against it. He has never seen so many suggestions of contempt, so many cases thrown out, so many accusations that department arguments were false, pretextual, or designed to fool rather than inform the court. And he noted that these characterizations are not coming from Democratic appointees. They are coming from judges appointed by every president. He then said the thing that is perhaps the most institutionally significant sentence in the entire statement. The Department of Justice and the United States government have lost their presumption of regularity in federal court proceedings. That is not a rhetorical flourish. The presumption of regularity is a legal doctrine, the assumption by courts that government actors have acted lawfully and in good faith unless there is evidence to the contrary. When that presumption is lost, it means courts are no longer willing to extend to the department the baseline credibility they would ordinarily accord to the government. Whitehouse is saying that point has been reached, that it is no longer presumed in federal courts that the Department of Justice is acting in good faith. So here is where this statement leaves us, and it is genuinely two-sided. Was Senator Whitehouse delivering a legitimate institutional warning, placing into the record a documented pattern of DOJ conduct that a constitutional oversight committee is obligated to examine before confirming its leader? Or was he using a procedural objection as a vehicle for a sweeping political indictment of a department whose policies his party opposes? Is the DOJ under Todd Blanche an institution that has lost its presumption of regularity in federal courts, or a department operating under unprecedented political pressure from an opposition that has made obstruction a strategic priority? Two different stories, same committee, same official record. Tell me in the comments which version you walked away believing. If you stayed this long, subscribe. The Florida court has its answer this Friday. The committee's record is already written.